The power of attorney forms the agency relationship, a clear separation of the principal from the agent. The individual is the suretyship 14th Amendment trust. The agent is the attorney in fact for the administrative organization. The agent has authority to act without necessarily any accompanying liability. The same way an attorney who is an agent does not go to jail for his client who is the principal. The power of attorney is the form to get us to the substance. The substance being that I'm the private representative of the government instrumentality organization that is doing business in my name. The right legal form to get us recognized in the right capacity is the power of attorney. The reason an adversary may reject your power of attorney is because it would require them to collapse a constructive trust they are operating through. The 14th Amendment trust, the conduit through which third parties and administrators do business in on or through the administrative estate. On this point, it's a powerful move to execute a power of attorney to a private individual who may need to act for your living estate in the event you are incapacitated. The indemnity agreement further documents your agency relationship. It's an agreement from the organization to protect you from personal loss or liability arising from actions you take on behalf of the estate. It formally states that if you act within your authority and something goes wrong, say an unforeseen tax issue or beneficiary complaint, the estate itself, not you, bears the cost or responsibility. The bond is issued by the estate. The security agreement is multiple pages. However, it's best to record only the first page and signature pages behind the UCC-1 filing. Your contracts are private property held in trust. Nobody needs to see your contracts. You only show up with your UCC-1 and original contracts when you need to enforce your security interest. And at that time, you would present a certified copy of the filing and at minimum, your authenticated security agreement, the original. The Uniform Commercial Code System is the codification of the English commercial common law, which was influenced by the law merchant, or lex mercatoria, one of the more fascinating, almost invisible legal systems that shaped global commerce. It wasn't state-made law. Instead, it was a self-regulating system older than the United States government itself. The entire commercial system depended on trust guaranteed by a third party and the surety long before modern banks or insurance existed. This is a custom UCC-1 form. The numbered sections on my form match up to the UCC-1 national form. We register the transaction in the national filing system. It's an obligation of the national government arising from the National Banking Emergency and Trading with the Enemy Act. In Box 1, the debtor is the estate created when you were born, written as an organization. Then in Box 2, the debtor is an individual surety or 14th Amendment citizen under the de facto government, which is a type of corporation. The secured party, as you can see, written in Box 3, A and 3B, is the living man expressed as a trust. In the earlier forms of this technology, it was taught that you write the secured party in upper and lower case letters to distinguish it from the debtor organization in all caps. However, this is a more accurate way to express the situation. Trust registration statements. An example, 3A says Sylvester Moore L., trustee under declaration of trust dated October 9th, 2025. And the additional secured party in Box 3B is Sylvester Moore L., general executor for the U.S. administrative estate, etc. Note on this UCC-1 that the secured party does not have a residential address. Let's look at the surety bond. You can see the President Roosevelt signing the Executive Order 2039 in the background. The bond names the current Secretary of Treasury as fiduciary, and it starts off with a declaration: know all men by these presents to facilitate lawful commerce in the absence of substance-backed currency in circulation. At the bottom of the bond, we have a mutual consent of 3 guarantors, certificate holders, who pledge their estate to underwrite the bond agreement. They each are secured parties already or are undergoing the commercial redemption process, as this transaction is sometimes called. So basically, it's best to do this in groups of 3, you and 2 others, or someone who is already secured. All the guarantors have private mailboxes, registered mail tracking numbers for their surety bonds, and United States authentication serial numbers as a guarantee on their pledge. Again, I'm referring to the numbers below the signatures on the bond. The authentication number is what we refer to as the guarantee number. It guarantees the authenticity of the pledge, which is a surety, the genuineness of the certificate, which is pledged as collateral to support the surety bond. The bond is a debt instrument, but in the commercial system it posts as a credit to our administrative estate. A bond, also by operation of law, releases the obligation of suretyship. The bond must be delivered to the United States Treasury with the pre-designated registered mail number, as you see on the face of the bond in the upper right-hand corner. The PS3811 is a green card that proves delivery of the bond to the fiduciary. The return and receipt of the physical green card should accompany your certified copy of the UCC filing in the event you are making a special appearance. As with every transaction involving money, the Treasury is a third party due to the national banking system, operating under emergency powers. Equally important as HJR 192, or even more so, is Section 5B2 of the Trading with the Enemy Act, as amended by the Emergency Banking Act of March 9, 1933, wherein it says, any payment, conveyance, transfer, assignment, or delivery of property or interest in property made to or for the account of the United States, or as otherwise directed under this section, shall be a full acquittance and discharge for all purposes of the obligation of the person making it. No person shall be liable in any court for or in respect to anything done or omitted in good faith in connection with or in reliance upon this subsection or any regulation or order issued under it. This goes with the endorsement on the back of the bond. In actuality, it's on the back of the certificate of live birth, which is the final part of the bond. The front of the certificate of live birth is attached to the United States authentication certificate, guaranteeing its full faith and credit, which is then attached to the surety bond and sent to the fiduciary. Also on the back of the COLB, one would naturally include their 9-digit SIN number without dashes. Without it, there would be no way for the secretary to know which account to charge or credit. The secretary is a fiduciary for the United States creditors. If you are a creditor of the instrumentality, you are a creditor of the United States. Paper money signed by 14th Amendment citizens fall under the government's regulatory authority. We have a national debt, a national banking system, and a national government carrying out the emergency banking acts. The bond is our commercial entry rebirth into this system as a creditor, a redemption of sorts. Section 9-203 of the Uniform Commercial Code tells us what's needed to have a valid and enforceable security interest in the debtor's collateral, which is the basis of this basic filing. Value has been given. The debtor has rights in the collateral or the power to transfer rights. And finally, there is an authenticated security agreement that adequately describes the collateral.
Can't pay debt with debt, that's the trick. The debt will double, triple, quadruple and flip. Before Civil Rights, Bill of Rights, UCC claims. Merchants had laws and traded in their own names. Word was bond and pledge was truth. Gold was the standard and trust was proof. Surety stood surely when the brother would slip. Like a boss, he covered the loss, he carried the script. No flags, no kings, no courts to call. Now banks play kings and debt rules on. It's the national system, money got flipped. Debt took its place, now we stuck in the script. Can't pay debt with debt, that's the